ಇಷ್ಟು ದಪ್ಪ ಓದ್ತೀರಾ ನೀವು? Mr. Prasad, please come and occupy your seat. Refreshment is on its way. Refreshment is on its way. ಇನ್ನು ಶಬ್ದ ಬರ್ತಾ ಇದೆ. speaker of the evening, Mr. K.N. Phanindra, senior advocate, who readily accepted our invitation to deliver this first program of this term, 2024-2026. A hearty welcome to him. And I welcome Mr. Acharya, although he is our senior most member of not only the bar but also our organization here. In the last 4 years, we have made tremendous progress under his stewardship. So, welcome to you, sir. And Mr. D.L.N. Rao, it is welcoming ourselves if I say welcome. He is a member, a old member, senior member of this organization and past president. Welcome to Mr. D.L.N. Rao. And I welcome all the senior advocates, students and faculty members for responding to our request. And you can now hear in a few minutes a very illuminating and enlightening speech. Mr. M.R. Naik, by the way, I am sorry, and Mr. Shantraj, Mr. Kantraj, both have the past and present chairman of the Karnataka State Backward Classes Commission. Welcome to you both. I am sorry, and yes. And additional advocate, former advocate general and former additional advocate general. So welcome to you all. Now we will start the program. Over to our secretary, Ms. Purnima Hatti.
Would you like to speak? Good evening, everybody. Thank you for joining us today for a very, very topical and constitutional lecture that is being discussed both within the legal circles and outside. It is my pleasant duty to introduce today's speaker, who is no stranger to us at the High Court Bar and those of you who may have interacted with him. But it is my pleasant duty to introduce Shri K.N. Phanindra, Senior Advocate. Mr. Phanindra is a designated senior advocate here at the Karnataka High Court. He completed his schooling from the National Public School and got his BA LLB degree from the University Law College. He joined the chambers of Shri D.L.N. Rao, who is here with us, and started his practice here at the High Court of Karnataka. He has regularly appeared here at the High Court as well as the Supreme Court, the Karnataka Administrative Tribunal, City Civil Courts, and the Family Court. He started his independent practice after 2004 with the law firm Hegde and Rao, which he established with Mrs. Vaishali Hegde with their offices here in Bangalore. Mr. Phanindra has been the standing counsel for the Karnataka State Board of Waqfs. He's also been the standing counsel for the State Election Commission for Karnataka until the designation of his as a senior advocate. Mr. Phanindra has also acted as a chief legal advisor to the State Election Commission in Karnataka. He's also been engaged by the Election Commission of India in several matters before the High Court, in matters relating to election disputes under the Representation of People's Act as well as the Constitution of India. He has also acted in a number of cases involving mining leases under the Mines and Minerals Development Act and their rules, Karnataka Forest Act and the Environment Protection Acts. He has regularly argued on a number of related issues and successfully defended these matters before the High Court here, High Court of Delhi, and in other fora. He has also been appointed as an amicus curiae by the High Court of Karnataka in several public interest litigations, including one on adequate safety and preventive measures related to dengue, related to the Right to Education Act here in Karnataka, and other issues around government schools. Sir, thank you so much for joining us today, and we look forward to this very, very engaging lecture. May I request you to give a warm welcome to Mr. Phanindra, and I request him to start the lecture. Thank you.
Good evening. Shri B.V. Acharya, President and Trustee, Karnataka Jurist Trust. Mr. V.S. Naik, President, Karnataka Section of International Commission of Jurists. Shri D.L.N. Rao, Senior Advocate, esteemed members of Jurist Commission. Mr. Naik, M.R. Naik, Chairman, Karnataka State Commission for Backward Classes, Mr. Kantraj, distinguished guests, friends, and everyone present. It's indeed my pleasure today to address this burning topic on the discussion of the present day relating to integrity and other things of the Election Commission. I would first start by quoting Winston Churchill, who said, "At the bottom of all tributes paid to democracy is the little man walking to the little booth with a little pencil, making a little cross on a little piece of paper." These words, the Supreme Court often has held, nothing more can be said about democracy than these words. The power of a person who casts his vote is what is democracy. Now, how do you protect democracy is the issue. If I take you back to history, we are talking about the Election Commission. The Election Commission of India is not concerned only with elections, conducting elections. There are various duties which the Election Commission of India has been conferred with by the Constituent Assembly discussions and by the forefathers. What are the functions of the Election Commission in protecting the democracy of the country? Number one, superintendence, direction, and control of elections is one duty. The second important duty is the preparation and the revision of electoral rolls. Of course, today you have been, for the past few months, we have been only hearing about controversies relating to the special revision exercise that has been taken up by the Election Commission of India in Bihar, which is now going to be taken up in several other states which are going into polls. That is one of the most important roles that the Election Commission of India performs. But except for the past few months, there had been no such concentration on this important duty conducted by the Election Commission of India. Now, the third most important duty in the protection of democracy is recognition of political parties and allotment of symbols. The fourth most important duty is the enforcement of the Model Code of Conduct. Without enforcement of Model Code of Conduct, there would be no free and fair elections at all. So this is another important duty of the Election Commission of India. And mind you, when I talk about Election Commission of India, it also comprises the Chief Election Commissioner and the present strength of 2 election commissioners. The last but not the least important duty of the Election Commission of India is in its advisory jurisdiction and quasi-judicial functions. Because when it comes to disqualifications of elected members for the Lok Sabha, Rajya Sabha, the state legislatures or the state legislative councils, the ECI either advises the president or advises the governors on disqualification of the elected members. So these are the broad functions of the Election Commission. Now, how did the Election Commission come into existence? The Election Commission, when we had we did not have a constitution. So when we got our independence, the Constituent Assembly, there was a committee formed to discuss on various roles and to give recommendations on how to frame the constitution. So the Constituent Committee, I would say committee headed by then Mr. Rao, of which Dr. B.R. Ambedkar was one of the most important members, came out with several discussions, came out with several reports, came out with several recommendations, which were debated in and out in the Constituent Assembly. And when you actually read the Constituent Assembly debates, you will find that whatever is being argued today, whether it's on the position of the election commissioner or the appointment of a chief election commissioner, everything was then debated. Some members had expressed their apprehension as to how the process for appointment of the Election Commission of India or the election commissioner should be taken forward. The debate also consisted as to whether the entire chapter relating to Election Commission of India appointment of election commissioners should be included in the chapter containing fundamental rights, because that was the most important chapter. Ultimately, on discussions, some of them felt it may not be included in fundamental rights, but a separate chapter or a separate part could be included, which is now framed as Article 324, which consists how an election commission should perform, how an election commissioner has to be appointed, and other parts. Now, I would only say why these things are important is, we find in the Constitution Article 329 having been included. Now, what this important Article 329 does is, it pushes out the remaining parts contained earlier to 329 from the Constitution, from judicial review. So what happens here is, if there is any election which is announced, which is being conducted, or which concludes, the judicial review of courts is virtually ruled out. There are judgments either ways, but most important judgments say even 226 gets pushed out because of the non-obstante clause contained in Article 329 of the Constitution. When such being the limited powers of judicial review, the powers of the Election Commission, the independence and integrity of the Election Commission of India and the Commissioner assumes the most important aspect. Because ultimately democracy, in my opinion, to a large extent is controlled, is ensured, remains free, uninfluenced, fair by the persons who man the Election Commission of India. It is in these circumstances our forefathers, the constitutional framers, thought of how to frame the Election Commission. This is why I say Election Commission assumes a greatest role, more than the role of the courts, when it comes to protecting democracy. I would only say the Constituent Assembly deliberations which took place, in which one of the amendments which was sought, which was raised by Professor Shibanlal Saxena in the debate, was when a recommendation was made that the Election Commissioner of India should be appointed by the President on the advice of the Prime Minister. This was one of the amendments which was proposed in the Constituent Assembly debate. So Professor Saxena immediately had raised raised a doubt, if the President has to appoint an Election Commissioner, CEC, then it was CEC, on the advice of the Prime Minister, whether the Prime Minister becomes the leader, because the President is anyway bound to accept the advice of the Prime Minister, and Prime Minister is the head of the government. So then the doubt that was raised was, it would mean that the Prime Minister would be appointing the Election Commissioner, and whether that would be fair. There were a lot of debates on that, which is recorded in the Constituent Assembly debates. Then Dr. B.R. Ambedkar also referred to the USA structure to say how Election Commission of India should be framed, how Election Commissioner should be appointed. But then Dr. B.R. Ambedkar himself refrained from adopting the American Constitution, saying, or the model of appointment of Election Commissioners, saying the American model contained more political appointments, it was more political based, and we should have a neutral based appointment of Election Commissioners, which mans the thing. Thereafter, a proposed amendment was made that an appointment of CEC and other ECs shall be subject to provisions of any law made by the Parliament. Now, this amendment was accepted, and today we find that in Article 324, which still retains that, which was adopted, which says that appointment of CEC and election commissioners shall be subject to law made by the Parliament. Of course, for more than 40 years, we did not have any law made by the Parliament itself till about 1991. The debates also concerned whether there was also further debates whether the Election Commission should be a permanent body or we should have election commissioners only when there were elections to be conducted. Luckily for us, they said it should be a permanent body. The only thing they did was, if it was felt necessary that the election commissioner or the chief election commissioner or the two election commissioners, or it could be more, felt it necessary that they would require more assistance in a poll-bound state, they could in turn appoint regional commissioners, or the president could appoint regional commissioners on the recommendation of the election commissioner. Till date, of course, there has been no appointment of regional commissioners. We are saved to that extent. Now, broadly speaking, there are several things which went on in the constituent debate, but what was most debated was whether a staunch party man as an election commissioner could be appointed. That's because what was said was the president will appoint on the advice of the prime minister. All parties across said there should be a law made for the appointment of the election commissioner. And today what we find is the current debate, which is under challenge in the Honorable Supreme Court, pursuant to a Constitution bench judgment, because one of the cases were filed in the Supreme Court where they said there is no basis, there is no law which mandates how the chief election commissioner or the election commissioner can be appointed. In the present model contained under Article 324, it only speaks of chief election commissioner or election commissioners. But the president has thought it fit, under the advice of the president, the prime minister or the government, that we shall have 2 more election commissioners. Of course, that was also a subject matter of challenge, which is known as in Danua case. First time in 1989, the government or the president made appointment of additional commissioners apart from the chief election commissioners. But then, having realized whether it should be gone on or not, it was immediately rescinded. That rescinding action was challenged by one person who was appointed as an election commissioner. And the Honorable Supreme Court at that point of time upheld the provision saying that there could be more than one chief election commissioner. Later we saw when Mr. Sheshan, T.N. Sheshan was the chief election commissioner, there were 2 other election commissioners for the first time appointed who took charge. That action was challenged by Mr. T.N. Sheshan, saying that there can't be 2 election commissioners, there can be only 1 chief election commissioner. But of course the Honorable Supreme Court, after considering the provisions of the Constitution, felt that there could be more than 1. Of course, the biggest debate was whether the election commission becomes a kingdom within a kingdom. If you're going to give them unbridled power, how do you control them? That was another issue which was raked up. Of course, the Supreme Court then clarified, though 324 does not give or mention anything to the commissioners, it's a vacuum. They said the election commissioner has all powers in exercise of 324. But if the election commission or the election commissioner exceeds its limits, judicial review to that extent is available, is what the Supreme Court laid down. One of the examples which was cited in Mohinder Singh's Gill's case was, you are saying 226 is out. If 226 and 32 are out and an election is announced, the election commissioner who is appointed by the president gives a direction to all the returning officers across the country, do not accept nomination papers from this particular political party, or reject all nomination papers from a political party. Now the judgment says 226, 32 are ruled out, 329 is a bar till completion of elections. Can the then Supreme Court or the High Court step in? That is to the limited extent, they said, the courts still retain the judicial review power in case the election commissioners exceed their limits. That is how we brought about this kind of a debate. But ultimately, when the matter was taken up by the Constitution bench relating to the appointment of commissioners, the Supreme Court examined so many provisions in other countries which contain provisions for appointment of commissioners. And if you see the other countries where the provisions for appointment of commissioners are concerned, in my opinion, I would say many other neighboring countries contain better provisions relating to appointment of election commissioners than India. In a country such as Pakistan, which is not known for democracy, when it comes to appointment of an election commissioner, they have a better mode. They have a better system in place where Everybody is involved. The opposition is involved, speaker is involved, the ruling party, prime minister is involved in choosing and selecting election commissioners. Unfortunately, in my opinion, in our country, we do not have that system. For 40 years, there was no law. When the Supreme Court laid down, you have to come out with a law. Since there was a vacuum, under 142, the Honorable Supreme Court said, let there be a committee for appointing election commissioner of India. Who are the committee members? The CJI, the Prime Minister, the leader of the opposition. And said, this system shall continue till a law is framed by the Parliament for appointing the commissioners. Of course, the ruling or the election commissioners who were holding post, they were due to retire. There would be vacancy in the office. At that point of time, in a hurried manner, I would say, the Parliament brought about a law giving a system of appointing election commissioners. Now, if you see that law, what they did was, they brought in a system known as a shortlisting committee and a selection committee. And they also brought in a qualification. What was shocking was, what was felt by everybody, that we should have someone with integrity, someone with qualification. There should be no set rules. The Parliament, if you see the latest amendment brought to the Parliament, you will see that a selection committee comprises, selection committee I'm talking about, comprises of the Prime Minister, a minister nominated by the Prime Minister, and leader of opposition. In the absence of a leader of opposition, the leader of the opposition party, which has the highest number of parties. But what is more shocking is the search committee. The search committee consists of 5 or 3 secretaries in the union government. So these people will shortlist a list of 5 members, and the qualification for an election commissioner of India or a chief election commissioner is the person concerned he should be holding or should have held the post of a secretary in the government of India. So what you have done now is, the post of election commissioner cannot go out from the bureaucrats. So it is only the executives. And the search committee contains only bureaucrats, including the Minister of Law, to shortlist the names for the election commissioners. So you have those persons who will shortlist 5 names of bureaucrats. That goes to the selection committee. Now, the search committee consists of a law minister. Now, the selection committee would also consist of a minister nominated by the Honorable PM and 1 leader of opposition. So the Prime Minister can always nominate the law minister to be a part of the selection committee. So you have 1 minister, 2 ministers, and a leader of opposition, and there is no rules laid down, no procedure as to whether the appointment should be unanimous, should be a majority, nothing. So normally the practice is it will run through a majority. But ideally, it should have had a larger spectrum. In fact, the Constituent Assembly had debated, most of them had recommended that a committee for appointment of an election commissioner should consist of the Prime Minister, leader of opposition, the Speaker of Lok Sabha, Speaker of the Rajya Sabha, Deputy Speaker of the Rajya Sabha also. So that there is a wider spectrum, because ultimately the election commissioner is the protector of democracy. If there is no integrity in the commission, not only the election, we all concentrate only on the election, but what is lost sight of is the other mandates which the election commission does. That is, it is involved in the exercise of preparation of electoral rolls and the advisory committee, and also the implementation of the model code of conduct. These two are more important than the conduct of elections, because without enforcement of the model code of conduct, you will never have a free and fair election, end of the day. And for electoral rolls, today most of you must be aware of the controversies that have erupted in our state particularly I think from the North Karnataka, that is Gulbarga side, where we have a SIT which is going into the issue of deletion of voters, then petitions in the Honorable Supreme Court relating to the special intensive revision roles which was carried out in Bihar, where allegations are made across the board on the Election Commission. Let me tell you, there could be a slight ingress or egress so far as it relates to appointment of election commissioners. But overall, in my experience of over 25 years, most of the election commissions deal, at least in certain aspects, with the most integrity and honesty. Electoral rolls is an exercise which is controlled under the rules. There are rules framed under the RP Act 1951, which controls how the electoral rolls should be revised or prepared, including additions, deletions. So when you have those rules, the Election Commission of India does not have independent machinery. It was also debated in the Constituent Assembly whether Election Commission of India should be provided with staff, a separate department to man entire exercise of elections. But unfortunately, most of the members in the Assembly felt, Constituent Assembly felt, since Election Commission is only involved at that point of time, they thought Election Commission will conduct elections only once in 5 years. So rest of the 4 years, why are we wasting money on the staff? Let us not do that. So the Election Commission is wholly dependent on the executive. It draws staff from the state governments. When it puts everyone, the deputy commissioners, assistant commissioners and others, for the preparation of the voters list. So when they depend, they do a overall supervision, superintendence to see that procedures are followed. There could be some mistakes in either preparation of the voters list or in deletions and additions, but that is a minuscule, but today we are making a mole out of it. A mole is being made a hill out of it, mountain. Otherwise, revision of roles is a regular exercise. It is only the nomenclature that has changed today. What we call as SIR or special intensive roles. It is normally done quarterly. Today it is quarterly. Earlier it used to be yearly. 1st of January it would get completed. Now it is done quarterly. There is nothing wrong in that exercise. And in Karnataka, Election Commission of India was the first agency, even in Gulbarga, North Karnataka, to have registered a FIR when it came to its notice that there was some lacuna, some lapses in the preparation of electoral roll where it involved deletion and additions of voters. But today, Election Commission of India faces flat, but it is used to facing flat. The entire flat is only because what I feel is the lacuna or the opacity in the appointment of election commissioners. Had the government of the day today sat down, thought of the process, what was expressed by the members in the Constituent Assembly, a wider debate, or had heeded to the advice of the Supreme Court, we would have been in a better position. Then nobody would have pointed fingers at the Chief Election Commissioner or the Election Commissioner at that point of time. What I find is, unfortunately, the government of the day felt the CJI need not be a part of the consultative process. We have the CBI in which CJI is also a part of the consultative process. There would have been nothing wrong. It was only to ensure that democracy is protected. That is the problem which we find. That is why today you have a huge noise being made by the opposition saying Election Commission has become partial. Now, why is that allegation being made? There are other issues involved. The Election Commission also assumes importance while it declares the elections. Now, the Assembly, under the Constitution, once the term of office of the Assembly, Legislative Assembly, is coming to an end, you can't have a vacuum. It should be filled up. So there is a time period within which the Election Commission of India has to conduct elections prior to the expiry of the term. Now, what is happening in the present past, what we see is the consultative process is not there. The government, when it knows it's the government or the which is in office, knows that the term ends in this period by this date. So what it starts doing is it starts announcing programs. The Election Commission of India should be aware of it. They should take proactive steps in announcing the schedule to the elections much prior to the date of expiry of the term. When the Election Commission of India starts delaying in announcing the schedule of elections, because the day election schedules are announced, the Model Code of Conduct kicks in. When the Model Code of Conduct kicks in, what happens is the government in power cannot announce any financial impact programs, that is to influence the voters. But the only complaint today is the Election Commission of India keeps quiet till all programs are announced by the ruling dispensation. And once the ruling dispensation finishes announcing all the programs, that you suddenly announce the schedule. This could have been avoided if we had a broader, a neutral party as the Election Commission. That is where integrity counts. That is where the appointment process starts. Now, I want to just show you examples or tell you examples about Nepal, my neighbor. That also has a council that recommends the chief election commissioner and election commissioners to the president for the appointment. Now, who is the council in Nepal? It includes, chaired by the Prime Minister, includes Chief Justice, Speaker of the House of Representatives, Chairperson of the National Assembly, Leader of the Opposition, and Deputy Speaker of the House. So that is a wide body which recommends the appointment of the Election Commissioner. If you go to South Africa, it is much more complex, but a wider thing. I was talking about Pakistan. Now, when we talk about Pakistan, no shall be persons of integrity and have experience in management. Now, this is as vague. Probably you are also disentitling other persons who could have made better election commissioners. A person of integrity. Why are you confining it to the executive itself? So then if you see the search committee, you have a selection committee. The executive today is in control of the appointment of the election commissioners. Did we want this system? If we did not have this system, probably we would have been better off. We would have been better off having the Supreme Court system where the CJA was a part. At least people would have trusted the Chief Justice of India when he renders his opinion in the consultative process when an election commissioner is appointed. Unfortunately, the government of the day did not want to have him on board. Let us see how the Supreme Court deals with it. Now, why do I say Election Commission is the guardian of democracy? That's because you have more than almost about 100 crore voters. We believe in adult suffrage. The Election Commission must ensure free and transparent elections. How do you ensure that? Number one, you have to ensure that the dates when elections are conducted are decided by the Election Commission on an independent basis without succumbing to the ruling dispensation. I refer to ruling dispensation because in any government, be it any political party, any state, it is the ruling dispensation which always tries to exert pressure on the Election Commission in getting the dates arranged for the election, or the flying squad who will ensure that the Model Code of Conduct is in force, that is, there are no processions, money is not transported, money is not used to bribe the voters. You should choose, that is the second most important aspect. The Election Commission has to guard that. That is when free and fair elections happen. I have had experience when it came to elections about 10 years ago in Bellary district. We had instances where for the first time the election came across, money being transported within car tire tubes. Till then it was not known. But then they found, because you had good officers on ground who could check the vehicles, and for the first time they came to know within the tires, within the tubes, money was being transported. Now today you have all modes, and now forget cash. The Election Commission is now trying to come out with a method as to how do you stop payments made through GPay, phone payments. Now the latest amounts that are being transferred to voters is through the online mode. Of course, I had the occasion to deal with elections with our Advocates Association. There were orders from the court that money should not be paid to the advocates, voters. Instead of cash, we caught many people where they were making payments through GPay, PhonePe, 1,000 rupees, 2,000 rupees as vote bribes. Now that is a huge thing which the Election Commission has to think. Of course, it requires, again, the support from the IT cell, support from the various sectors as to avoid it. Because the candidates will never spend money through their phones. It is the supporters. And those supporters, how do you check? How do you curtail this trail of online money? That is the second thing which the Election Commission is presently considering, and that is what is important for a free and fair election. Money, if you ask, it can only do to an extent. Beyond that, nothing more. Now, when it comes to voters list, Election Commission should ensure, keep a watch, take strict action whenever it finds that the officials, that is the electoral registration officers, they are of low rank, assistant commissioners, tahsildars, if they unnecessarily delete voters or add voters without giving notice, without giving opportunity, if there is a mistake, you should take immediate disciplinary action. In fact, I have always suggested that an amendment should be brought to the service laws, whether it is under the KCSR, whether it's under the central rules, that for taking disciplinary action at the point when these officers are on deputation, because all these officers, when election duties are ordered, that is when an election is declared, they are deemed to be on deputation with the Election Commission. So these officers, if they commit any mistakes, the Election Commission itself should initiate disciplinary proceedings and then punish them. That is when you send a sound signal to the electorate or the citizens. But unfortunately, what happens is the Election Commission only recommends to the state governments or the central governments when there is an error or a error committed by an officer to take disciplinary proceedings. After that, the Election Commission has various roles it has to play. It will not follow up. And normally what we see is the central or the state governments will go slow on taking action against the officers, because ultimately it is the executive. A bureaucrat will have to decide against his fellow brother. So he goes slow. And normally if any action has to be taken by a DO, that is a district electoral officer, he would normally be of a rank of an IAS officer. And you have an IAS officer deciding against an IAS officer, nothing happens. And we have seen allegations being made. Revision of electoral rules, I would say, to a large extent, there has been no mistakes. Yes, to an extent, there would be mistakes, because today we hear complaints, we see in debates, you see in TVs, in one house, Election Commission has included in one building 100 voters, 120 voters. So they have not done this exercise, they have played with the ruling dispensation. This kind of an argument, to my memory, was argued about during the past assembly elections, when a whole day was spent in Court Hall 1 in defending the electoral rolls for Shivajinagar constituency, when the allegation was in one number, house number, more than 150 members had been enrolled as voters. Now what was shown finally to the court was that one number is on paper, but that one number was a huge building with small tenements having more than about 50 houses, and that is how 150 voters were there. So on TV debates, we just go by concerns that Election Commission errs. But no, Election Commission does not err. It is the officials sometimes who err, and that is where the Election Commission has to be guarded and take care. That is what I say. Voters list is the most important role. Code of conduct, yes. one more role for the Election Commission. The other role is the advisory role. The advisory role comes in when the President or the Speaker asks them about disqualification. That is yet again an important role, and that can be performed only by an election commissioner who is independent. We have come across, in my personal experience, I have seen some election commissioners, though they were bureaucrats, though they were secretaries, are independent. But some always succumb to pressures. That is because they are, end of the day, they were executives, they were secretaries. Somebody will simply put a emotional blackmail. ಏನಪ್ಪ ನಾನು ಕೆಲಸ ಮಾಡುವಾಗ ನನ್ನ ಹತ್ರ ಮಾಡಿದ್ದೆ, ನಾವು ನಿಮಗೆ ಈ ಥರ ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಟಿದ್ವಿ, ಮರ್ತು ಬಿಟ್ರಾ? He does not want any bribe. He does not want it. But the emotional blackmail comes, and then he becomes softer. He would think twice whether I should recommend, whether I should take action, whether I just ignore this. This is what is to be avoided. And all these things, an election commission's integrity will only stand only when you have an election commissioner of India and 2 election commissioners appointed by broad consultation, so that everyone knows this man is a neutral man, he will work for democracy. The other most important thing, any person who has to be shortlisted as an election commissioner or a chief election commissioner should not have any political affiliation. Now the Act strangely has given a period, cooling off period, post-election commissioner's term. I would say there should be a cooling off period. You appoint only retired bureaucrats. Do not go to appoint serving bureaucrats, because the Act today provides for appointing a serving bureaucrat, that's a person who is holding the post of a secretary in the Union of India. I would say no. Give them a cooling off period. Let them retire. 2 years cooling off period. And then you want to bring in bureaucrats, bring them, because by then at least their concern for one dispensation is not there. Otherwise you have someone who will always have some favors, and that should be avoided. This is what we felt. That is what I have felt. In fact, since we are talking about leader of oppositions, leader of the Prime Minister and the CJI, Justice M.N. Venkatachalaya's committee had also given a report way back in 2002, where they had also suggested it shall comprise of PM, leader of opposition in Rajya Sabha, Speaker of Lok Sabha, and Deputy Chairman. This is how everyone thought, that when you have a guardian of democracy, the person who mans that guardian of democracy should be someone who is absolutely neutral. If you do not have that, then that will collapse. Then you had a Veerappa Moili's committee report of 2007, which again said Ministry of Law and a committee on electoral reforms. In fact, they went a step ahead and said we need a committee on electoral reforms because of the experience earned. When the framers of the Constitution, when it was framed, it was almost 50-60 years. Nobody thought these days would come. But some of them thought, some of them said, do not give only one person the right to appoint. In fact, Veerappa Moili also suggested we should have a committee which will decide how to take about electoral reforms. Electoral reforms not only means appointment of commissioners, but also how should elections be conducted? Who is the body to oversee that? What are the punishments? Let me also tell you, when we come to electoral offences, if you see IPC today, BNSS, I don't think we will come across even a single conviction when it comes to violation of Model Code of Conduct. Sandesh will agree with me, because you will always have a technical effect. They will only cite 188 of IPC and a complaint to the police. Ultimately, the court says it is not a it could be a cognizable offence, but a complaint should be filed to the magistrate by the authority which implemented or which came out with Model Code of Conduct. Now, Model Code of Conduct is by evolution by the political parties, for which the Election Commission has given its seal. You cannot have an election commissioner going before a magistrate filing a complaint. That is what is happening today. That is why the integrity, the honesty, and the appointment process is as important for an election to be fair, free, and for a democracy to survive. If these two are not there, whatever elections you have will be a farce, and even the courts will not be able to do anything. I think I have wound up. I'll wind up because the time, I think, is running out. Otherwise, I could have gone on about Canada, Ghana. There are so many. If you see any other country, I always feel they have a better system. And let me tell you, so far as conduct of elections, all other countries always say India has the best system of conducting elections, because the Election Commission ensures every corner, whether it is motorable or not, a booth is set up so that nobody loses his valuable vote, which is not happening anywhere. I am sure if you see the presidential elections in America or any other election, nobody will understand who is winning, who is losing. If you see any other countries, they still follow the paper ballot. We have come out of paper ballot, EVMs. EVMs checked once, thrice, I don't know how many times each one challenges EVMs, saying it can be forged, it can be hacked. The Election Commission has thrown an open challenge to all the political parties or anyone to come and prove that it can be hacked. Nobody has succeeded. But today again we have clamoring by certain political parties that we should go back to the ballot paper days, though we have advanced to the EVMs. I only hope the Election Commission becomes proactive, or the ruling dispensation without any ego says, yes, though we have brought in this act, maybe we'll improve upon ourselves and bring in a more consultative process. After all, it is for democracy, end of the day, because today's ruling dispensation can be tomorrow's opposition also. That's it. I thank you one and all. It's there. I am running only because of the time.
Thank you very much, sir, for that very interesting lecture with both a comparative framework as well as an understanding of how the Commission works. May I now request our chief guest for the evening, Mr. D.L.N. Rao, to make some remarks.
Good evening, everybody. I have some difficulty with my voice. Hopefully you will understand me. Today is a very important day for me. It's one of the happiest moments of my life. The first lecture for the present present term of the Commission is started by none other than Shri K.N. Phanindra, one of the most interesting person, very well read, and such a humble and humble person that he is. It makes me feel extremely happy. One other reason why I am so happy today is I have just 3 days ago completed 55 years of practice. I got enrolled on the 26th of October 1950. So 55 long years. Only after my senior, Shri B.V. Acharya, who has completed 65 years or 70 years of practice. 68 years. He is called the Bhishma Pitamaha. Now, as far as the remarks are concerned, what is it that I can add, or what is it that I can say after hearing such an illuminating lecture by Sri K.N. Phanindra? C.K. Allen, one of the greatest authors, in his book on democracy and the individual, has specifically said democracy leads to mobocracy. That is what Mr. Phanindra, in one particular stage of his speech, has clearly said the role of money that plays in the elections. It is just mobocracy. You have one lorry full of people coming there voting, and then they are left in the lurch after some money is being paid to them. If this is the form or method of election, then God only save the country, God only save the constituency. But he has added a rider to it by saying, Election Commission has several roles to play. Two of the most important roles are finalizing the voters list, ensuring following up of model code of conduct. And he also cited that most of the other countries do not have a better process of election, though several countries, even they may be a small country, have better method of selecting election commissioner. Election commission, as he rightly said, was debated in the Constituent Assembly, and they unanimously agreed to put it in the chapter called Fundamental Rights. But later somehow they felt there should be a separate chapter, and that is how it started with 324 in the final analysis of the Constitution. Now, we read so much about basic structure of the Constitution. Can we call the election commission and the role of election commissioner and also the model code of conduct, etc., can all these be put in a pot to call it as basic structure of the Constitution, which cannot be altered at all? Because a country runs in a democratic manner unless you have a very strong basis of selection, strong basis of election. These two are extremely relevant. Now, there is an enactment made by the Parliament in 2023, that is the Chief Election Commissioner and other election commissioners' appointment, conditions of service and terms of office. This is a parliamentary enactment. In this, there is a clear indication. If you look at section 11, resignation and removal. The Chief Election Commissioner or an election commissioner may at any time, by writing under the hand addressed to the President, resign his office. So it is a voluntary act on the part of the Chief Election Commissioner. Then subsection 2 says, Chief Election Commissioner shall not be removed from his office except in a like manner and on the like grounds as a judge of the Supreme Court. How easy or how difficult it is to remove a Chief Election Commissioner? It is extremely impossible. So if something which is very difficult but has a great value in the Constitution and in our day-to-day lives, the removal of Chief Election Commissioner being made so difficult, the appointment of Chief Election Commissioner also, as he very, very rightly pointed out, should have a broad basis. There were no rules for nearly 40 years. There was no guidelines. And somehow the elections went on and election commissioner started elections, etc. If that be so, can we not have a broader basis of selection? Now the committee has only three: the Prime Minister and a cabinet minister nominated by the Prime Minister and the leader of the opposition. What can you expect? You cannot expect anything other than what the ruling party wants. And if he is a man who is susceptible to the ideology of the ruling party, then God only save this country. But election commissioner should be a person who has a very good character and conduct. I won't mind even if his qualifications are a little lesser than the others. But integrity, honesty must be there in Chief Election Commissioner's mind, always. And he has a right to remove other commissioners, but he can't be easily removed. So the appointment also should be interlinked to say that his appointment must be in such a manner that it is done with a lot of ideology in mind, and that is where I feel, can we call it as a basic structure of the Constitution. It is important now, in the present day circumstances, the Chief Election Commissioner should have a great role to play. Just a small aside, I would like to share with you, when Mr. Seshan was the Election Commissioner, 2:30 we had a meeting and he was to address the Advocates Association. 2 o'clock, all Sessions dogs came in, they were sniffing all over the place. 2:30 promptly Session came. He started by saying, first all session will come, then Session will come. That is how he started, very humorous, but extremely talented man. Sometimes his ideas are good, so good that implementation will have some kind of a, some kind of a difficulties for the ruling party. I can put it in that manner. But nevertheless, he was a fearless election commissioner. He fought that there should be only one election commissioner, there can't be more than one. Then somehow now things have changed, and because of workload or because of political reasons, there could be one chief election commissioner, more number of election commissioners. That is the present stage. Now, after hearing Mr. Phanindra, in a detailed manner, he has step by step, starting from the Constituent Assembly debates up to the latest Act of 2023, he has analyzed and he has put it in a cryptic manner, and anybody can easily understand what the present situation is. If I try to add something more, I'll be spoiling the whole lecture itself. So I would rather close my remarks here, and then I profusely thank Mr. Phanindra for his illuminating lecture. He incidentally was my junior and was an asset in my office. He and Vice President Madam Anuradha, they both were my colleagues. Huh? Yes, so very kind of you. So I had a lot of asset in that forum. That is more important, and they helped me a lot, and they were also important in shaping my career also, apart from shaping their own career from my little knowledge. Thank you very much.
Mr. President, Shri Phanindra, our chief guest, Shri D.L.N. Rao, Mr. M.R. Naik, Mr. Kantaraj, Justice Ashok Nijagundanawar, and all my friends and dear law students. As Mr. D.L.N. Rao said, after hearing a most highly educative and exhaustive talk on the subject dealing with different aspects of the law on the point, I don't think I could add much. I really appreciate the talk by Mr. Phanindra, and I sincerely thank him for the great effort that he has put in. I can boldly say that he is an expert in the field of electoral law, and it is my privilege to share this dais not only with him but also with his senior, Mr. D.L.N. Rao. In between, it is a great privilege for me. Now I will take very little time only on one aspect I want to say. As already stated by the guest speaker, appointment of the election commission is the most important thing rather than the removal. Regarding removal, what Shri D.L.N. Rao read is in the constitution itself. The chief election commissioner can be removed only in the mode of removal of a Supreme Court judge. Though same doesn't apply to the other election commissioners. And constitution itself provided chief election commissioner and other commissioners as the government decides. And as he said, for 40 years we had only one chief election commissioner. The two other commissioners the government appointed only when it found that Sheshan has become very, very strong. So how to control him? To have two more and then say the decision of the majority will be there. And one important thing, we are very grateful to the Constituent Assembly members who have given us a good constitution. But they having known that appointment of election commissioner is the most important thing, as good as appointment to the higher judiciary, Supreme Court or High Court, or even more important than that, after good deal of deliberation, as explained by Mr. Phanindra, they failed to incorporate a specific provision. So they virtually abdicated that and said, let the parliament pass a law. That is that according to me is the fundamental mistake. The constitution itself should have provided for appointment of the, and since it is left to the parliament, constitution said till such a time law is made or subject to the law to be made by the parliament, the election commissioner will be appointed by the president. That is aid and advice by the cabinet only. Instead of prime minister, it is the cabinet that is to be appointed. So the government enjoyed that power. But ultimately, now the Supreme Court said, though it gives power to the parliament to enact a law, it is not, it is obligatory. The provision doesn't say obligatory. Supreme Court said it is obligatory. And till you make that law, though you have not made it for 40 years, till you make it, we appoint a committee. Leader, Prime Minister, Leader of the Opposition, and the Chief Justice of India. That was the position. Now to get over this, in a hurry, as he said, they brought in a law. Because in the law, they retained Prime Minister and Leader of the Opposition, but conveniently omitted CJI. Instead of CJI, they said a cabinet minister to be nominated by the Prime Minister. It is worse than even a clerk in the office of the Prime Minister. At least a clerk you can't remove immediately without an inquiry and all that. But a cabinet minister is merely there at the pleasure of the Prime Minister. Immediately he can be removed. Now, what is the point in saying a cabinet minister to be nominated by the Prime Minister? It is absolutely meaningless. Therefore, rightly, this law is now being challenged, and I hope the Supreme Court will take note of all these things. And according to me, there is a very good chance of the Supreme Court saying, Mr. Rao said earlier, that holding of a free and fair election has now been held to be a basic structure of the Constitution. Therefore, if the Supreme Court finds there is a method of appointment now adopted under the Act will affect the basic structure, they can strike it down on the ground that you are not having a independent body to conduct the election. Therefore, it is bad. Whether we like Pakistan or Sri Lanka, which country as it is, we will not mention the name. But as I said, I 100% agree that the method there is far better. And we should consider having, now instead of Prime Minister, Leader of the Opposition, and CJI, I agree the judiciary, particularly CJI, should not be involved in any election process. It is not proper. Tomorrow, if it is challenged, it will have a sad reflection. Instead of, I suggest you can make it broad-based, as he said, that is Vice President and Speaker, and if not, at least Prime Minister, Leader of the Opposition, and a eminent person to be nominated by the CJI. That would at least show there is one independent person apart from the Leader of the Opposition and the Prime Minister. If the cabinet minister nominated by Prime Minister, which cabinet minister will side the Leader of the Opposition? He will always go with the Prime Minister. Therefore, I hope the Supreme Court will take note of all these things. And I think if Mr. Phanindra could have been appointed by the Supreme Court as amicus curiae to point out how the new law, the Supreme Court can give suggestion how the new law can be drafted. So, once again, I thank all of you for your esteemed presence, and also, once again, I thank Mr. Phanindra. Thank you very much. Thank you.
Good evening to everyone. A very eventful evening, as you have seen. The eventfulness was explained how two prominent persons, junior and senior, have brainstormed you all on election laws. And I am only just adding a little bit of butter, I think, to the whole. I think what we should remember is prior to the independence, before we got our constitution, the persons who were eligible to be voted were only either graduates or who filed income tax, so returns. So from there, we have come a very long way in the sense that we all have a right to vote. And that, the way that is managed We have heard how that is being done. I only thought, sir, if I could take the opportunity to add, we could even consider having a ex-chief commissioner as the third person in the committee for selection. So that would be one thing. With that, it becomes difficult. Senior has grained us so well that when the mind starts thinking, you also feel like expressing it. So I take this opportunity to thank the chief guest for this evening, Shri D.L.N. Rao, my senior. Pranams to you, sir, and thank you. I also take this opportunity to thank our esteemed speaker. Your talk is about the entire process of election has been very enlightful for everyone. We truly appreciate the time and the thought that you have taken to prepare for this. It was indeed a scintillating one, is what I can say. And I wholeheartedly, from myself and on behalf of the Commission, thank you very much. And I request his senior, Shri D.L.N. Rao, to hand over a small memento. I also take this opportunity to thank our past president, Shri B.V. Acharya, who who's a huge repository of knowledge of all kinds. On any subject that we have a talk, he has something like a bank to contribute. So thank you very much. I myself, on my personal behalf and on behalf of the Commission, thank you very much, sir, for your insightful thinking. I said today has been an eventful day. It has also been an eventful day because you have the couple. One fed your mind, another fed your stomach. Today's evening's tasteful snacks and scrumptious MTR snacks were sponsored by Mrs. Vaishali Hegde, a wonderful host. She ensured that everyone who came to hear her husband had a full stomach. I take this opportunity to thank all the young minds who have felt to attend an in-person session and have this interaction and get intellectually stimulated. Thank you, students, for coming. And I should not forget that our beautiful smiles and beautiful expressions on our faces are captured by Mr. Chandrasekhar, who is, sir, why don't you please come in the front? Mr. Chandrasekhar is an advocate by profession, and taking snaps is his passion, and a part of his passion, he has helped us today in capturing both video and audio. Thank you. And this program is being live streamed now, so I also thank our live streaming partner for the same. In the end, I thank all the dignitaries, His Lordships, senior advocates, and all the other advocates who are present today. Thank you, one and all. Sir, I will like students. Yes, students. Thank you. Thank you very much. And until we see you for another next intellectually stimulating evening like this. Thank you.